Hello, everyone, and welcome to a new Q&A with Chuk attorneys and CPAs. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chuk LLP, tuning in from our San Diego office. Please join me in welcoming attorney Belma Burkic from our Houston, Texas office. Hi there, Belma, and welcome.
Hi, Arianna. Thank you for having me.
Thank you for being here. So for today's topic, we're going to be talking all about the new USCIS fee increases. This conversation is for informational purposes only. It does not create an attorney-client relationship, so please send us your questions at info@chuk.com so we can help you out. So Belma, why did USCIS implement these fee increases? Can you share this with us?
Of course. So, unlike many other federal agencies, USCIS is almost entirely fee funded. Approximately 96% of its funding comes from filing fees. So, in the wake of COVID-19, when immigration filings decreased by 40%, USCIS instituted a hiring freeze, which, coupled with the workforce attrition and then the subsequent increased filings in the years since, reduced the agency's capacity to timely adjudicate cases. This resulted in significant case backlogs that continue to persist today. So with the new fee schedule, USCIS believes it can recover its operating costs more fully and support timely processing of these applications. The idea is that they'll be able to hire more analysts so that the backlogs do not continue.
Understood. So this is supposed to help us to allow them to process our applications quicker and sort through more of them. So when will the fee increases be effective? Do we know this information?
So the new fees will be effective April 1st this year. So that means that applications and petitions postmarked on or after April 1st that do not include the new fees or new versions of certain forms will be rejected.
Got it. So can you share with us what will these new fees look like? Do we have any information on that?
So we do. USCIS released a detailed fee schedule on their websites, and the fee adjustments will impact a broad range of visa categories. So it's not just going to be limited to employment-based categories, which is what I would like to focus on today, specifically I-129 and I-140 filings. But before we get into the numbers, I should mention that USCIS did try to minimize the financial burden on small employers and nonprofits, typically subjecting them to reduced fee adjustments. So small employers are defined as businesses with 25 or fewer full-time employees. So to answer your question, what are some of the fee increases that we're going to see? First, as part of a new rule, USCIS has attached an additional asylum program fee to most I-129 and I-140 filings. This fee is really meant to clear the backlog of the 3 million pending asylum cases currently sitting with USCIS. The fee is $600, but there are two carve-outs here. First, small employers will be required to submit a reduced fee of $300 with their I-129 and I-140 filings, and nonprofits will be completely exempt from this fee. In regards to I-129 filings, the current fee of $460 will increase based on the type of visa classification that's being requested. So for example, for H-1B petitions, the current fee will increase to $780, which is a 70% increase from the $460, which is the current fee. Again, the carve out here is if you're a small employer or nonprofit, the fee for an H-1B filing will remain at $460. The other notable thing with regards to H-1B filings is within H-1B CAP registrations. For this year, USCIS will keep the fee at $10, but for next year's CAP filings, the cap registration fee will increase to $215 per application. L1 petitions will see an increase of over 200% to $1,385. Again, small employers and nonprofits will be subject to a reduced fee of $685. We're also going to see increases with e-filings, H3, TN, P, Q, and R classifications. They are going to be $1,015 and $510 for small employers and nonprofits. O1 petitions will also see a significant increase from $460 to $1,055. Again, carve out being made for small employers and nonprofits with a reduced fee of $530. So the most significant fee adjustments will really be within the I-129 category. The I-140s are only going to be minimally impacted by these fee adjustments. We're going to see a 2% increase to the USCIS filing fee, and that will be set at $715. I do just want to mention that we will also see an increase in the adjustment of status application filing fee. By $300, it's going to increase to $1,440 for applicants age 14 or older. But really what should be noted with this, with the adjustment of status filings, is that the I-765 fee and the I-131 fee are now going to be unbundled from the I-485 fee. So the I-765 is an application for work authorization, and the I-131 is an application for a travel document. So historically, applicants, or not historically, but most recently, applicants would submit one fee to the government for the combined filings of the 485, the 765, and the I-131. This fee unbundling is now going to increase the cost for applicants seeking a green card.
Wow, thank you for sharing with us all of those fee increases. Some of them are quite large, so I do appreciate you taking the time to share with us what those actually look like. And it is nice to know that small businesses do have some leeway with these really increased fees. So thank you for sharing that with us. Are there any additional notable updates with USCIS that we need to be aware of?
So USCIS published within the January 30th final rule that the premium processing timeframe will increase from 15 calendar days to 15 business days for applications that qualify for premium processing. So that's an additional week processing. And that comes on the heels of a $300 premium processing increase fee that took place at the end of February. The other thing to mention is that for forms where USCIS offers online filing, there will generally be a $50 discount for those who choose the online option over the paper filing. However, this may offer little relief compared to some of the fee hikes that we're seeing. And there are also reasons as to why employers may prefer to continue with the paper filings, as my colleague Min Kim discussed in last week's Thursday live session. And then, lastly, as I mentioned above, USCIS will only accept new versions of certain forms for cases postmarked on or after April 1st. Those forms are the I-140, the I-129, I-129CW, the I-600, and the I-600A. So if you're filing a case on or after April 1st, you must use the new forms and the new fees. There's absolutely no grace period.
I appreciate you sharing that with us. That's really important to know. And as you mentioned, Min did cover some of these things in the last session. So if you guys do need more information on the USCIS updates, do check our other lives on this topic as well. So Belma, how should employers calculate the new USCIS fee?
So there is a fee calculator available on the USCIS website, but currently it does not support calculations for I-140 or I-129 filings. So employers will have to take a look at a variety of factors, such as the size, whether or not it's a non-for-profit organization, the visa category that's being sought, as well as the type of filing, whether it's an initial filing or an extension or a change of employer. So just to give you an example, the filing fees for an initial H-1B filing for a large employer who's not subject to public law 114-113 and who's not filing premium processing, the filing fees will include an asylum fee of $600, the I-129 fee of $780, an anti-fraud fee of $500, and then the H-1B education and training fee of $1,500. So when you compare the final filing fee cost, that's a $920 increase over what the current fees are. And then it's even higher for L1s, which will include an asylum fee, again, an L1 for a large employer not subject to public law or filing via premium processing. That's going to include an asylum fee of $600, an anti-fraud fee of $500, and then the I-129 fee of $1,385 fee. When compared to the current filing fee cost, that's over a $1,500 fee increase.
Wow, so quite a few increases here that we need to take a look at. So a lot of people are probably thinking, should I just file now instead of waiting until the fee increases? So can we avoid the new fees by submitting our applications before April 1st?
The short answer is yes, of course, but there may be good reason as to why a petition or application cannot be submitted prior to this date. So for example, it wouldn't make sense to rush to file a really complex case like a complex L1B or an O1 without all the necessary information, because that may end up resulting in a request for evidence, which will delay the overall processing time and also lead to increased legal fees. And in some instances, you're just not able to file because there are certain regulatory requirements. So for example, in the case of extension requests, they can only be submitted 180 days in advance of the current I-94 expiration date. So definitely recommend that you work with legal counsel to determine which cases can be filed prior to April 1st in order to try to avoid the fee increases.
That's really good to know. So if you do want to file before and you think you can and you have all of the information on hand, do reach out to us. We're happy to help you out with this and see if this is something we can do for you and get things filed before the fees increase. Thank you for sharing that with us, Belma. So employers and employees alike often inquire with us as to who may pay immigration sponsorship fees for certain non-immigrant petitions and the permanent residency or green card process. Can you provide some insight into that for us?
Sure. So the answer on who may pay often depends on a few factors, including the specific immigration process, who's requesting the fee, the visa type, the specific expense, and even state employment law considerations. There are some fees that simply cannot be passed on to the employee, especially in the NIV context. So, for example, federal law generally prohibits an employer from requiring an employee to pay for or seek reimbursement for the employer's expenses for the filing fees or attorney's fees associated with the preparation or filing of an H-1B petition. So this means essentially that an H-1B employee cannot pay the legal nor the I-129 filing fees, nor can those fees be deducted from their base salaries, as that would be considered an offset against wages and benefits stated in the labor condition application. This also applies to H-1B1 and E3 as well.
Understood. So it sounds like employees are not allowed to pay for this. The company has to pay. Are there fees that employees can pay out of pocket?
Sure. So one example would be premium processing fees. They can typically be paid out of pocket in the NIV context, depending on the circumstances and if certain conditions are met. Another example are legal and filing fees associated with filings for dependents. And there are also instances where the I-129 fees can be covered by an employee, such as in the case of TNs. But that being said, I strongly recommend connecting with legal counsel and in-house employment law counsel or external employment law counsel before making any changes to immigration policies or passing the cost, as there may be employment and immigration related reasons not, immigration law related reasons not to.
Yeah, it's important to keep in mind that there are exceptions to this. So if you guys do have questions, please reach out to us anytime at info@trig.com. We'll connect you with Belma and she'll help you out with this. So Belma, what are the rules around fees associated with the permanent resident process?
So the most common employment-based permanent residency process can generally be broken down into three major steps. So step one is the PERM or the labor certification application. And so according to federal regulations, the employer is responsible for all fees associated with the PERM application process, including legal fees and costs of recruitment. Now, this is different for the step two, which is the I-140 filing, where the employee can cover all USCIS filing fees and legal fees associated with the petition. And the same is true for step three, which is the I-485 adjustment of status. According to federal regulations, the employer is not required to cover the costs associated with this process. Um, again, there might be reasons as to why companies would want to keep covering these costs if they already do. So if you are considering any changes, it's best to discuss both internally and externally with legal counsel.
Yeah, that's really important for all employers to keep in mind right now. So looking at all of these fee increases from a greater perspective and taking all of that into account, what are some of the possible impacts that you foresee as a result of these fee increases? What is that going to look like for businesses?
Yeah, so given the fee increases with the employment-based petitions, some employers may be forced to not only revisit their immigration budget for the year, but to also revisit their immigration policies and the types of cases they cover the expenses for. This could result in employees carrying a greater burden of immigration fees as permitted by federal and state employment laws. So what that means from a practical standpoint, with regards to immigration policies, is that it could result in the employer no longer being able to cover some of the costs that really allow them to offer their employees a robust immigration program. And that robust immigration program may very well attract and retain their foreign national population. So, for example, they may no longer be able to promise green card sponsorship upon hire or within 1 year of hire for employers that have that policy. Or employers may be required to adjust their premium processing policies and cut back on premium processing filings or the types of cases they're eligible for premium processing under the employer's policy. They may also look to amend their policies with regards to H-1B sponsorship or L-1 sponsorship, determining who qualifies for it. Some employers may also cut back on covering the fees associated with dependent filings and adjustment of status filings. So the bottom line is that depending on the size of the employer's budget and the size of its foreign worker population, these fee increases may result in changes to the way that they govern their immigration program. If changes are needed, then might be a tough sell as a robust immigration program attracts talent.
That's a great point that you mentioned, Belma. It is something that companies really need to consider. Is this something that they can fit into their budget? What changes and adjustments do they need to make in order to accommodate these fee increases? And, just to mention for anyone watching, we do have an accounting team on staff as well. So if you guys have questions about reworking your budget, we're also available to help you with that. So Belma, what can employers do now? all of these fee increases, they're going to have to maybe change their policies and figure out where they need to make cuts and change things. So what can they do now with all of these changes?
So just before I answer that, disclaimer, I'm not an HR professional, and these are just my opinions and recommendations. They do not constitute legal advice. But one of the things that jumps at me, and one of the things that employers can do now, if they haven't already, is start analyzing the impact to this year's immigration budget. So what that means is taking a look at your foreign national population and understanding the potential population impacted by the fee increases this year. So that means identifying employees that will require an extension this year, or those that may require an I-140 or adjustment of status filing. It may also require you to do a projection based on how many expected amendment filings, change of employer filings, initial filings, or even cap filings your company expects to file, and then understanding whether those filings still fall within your immigration budget. I would strongly encourage to discuss these fee adjustments with senior management to determine the necessary course of action that makes the most sense for your organization and your employees.
Thank you for sharing all of those great points with us, Belma. That is something that companies really need to focus on right now with all of these coming fee increases. And, they are starting in April. So we really do have to take this on quickly and figure out what the plan is. And if we can file before that, then great. If not, then, we have to figure out what we can do internally to accommodate these changes. So you mentioned a lot of the fee increases and what those jumps are going to be. Is there somewhere that we can find more information about these new fees? Where can our viewers look to see all of the changes, the new increases, or updates on what these new fees are?
So a full list of the new fee schedule can be found on the USCIS website. The Chug blog also contains information on this topic, so feel free to navigate our website for that. And if you want to see the final rule with all its legalese, it has been published in the public register.
Wonderful. Thank you so much, Belma. And very true point. We do have a Chug blog on our website that does update everything from USCIS. So make sure you check that out. Make sure you sign up for our newsletter. That is all we have time for today. So thank you so much, Belma, for joining us. And thank you everyone for tuning in. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please email us anytime at info@chug.com. We'd love to help you out. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you so much for joining us.